So that would be a separate filing, and that would be restricted to wetlands and riverfront impact. It wouldn't necessarily be associated with the allowed use, if that makes sense.
I mean to see, should I expect another meeting similar to this? So people vote on yes or no, yes, her ADU has everything, things like that.
Well,
Should I expect that? Yeah,
Pam,
go
if you
ahead.
can
Sorry.
jump in terms of our purview and authority, I think we at this point, with the correction of the setback, have what we need. But the final approval of the building per se will depend on the outcome of the application through the Conservation Commission. Pam, is that correct?
Yes, that's correct.
I have a question on the second driveway. So I
Let
see
me-
it's like on Coventry Wood Road. What's the deal with like mail? Like, is there address? Is there an address to this attached unit, or
When
Is
they
it-
apply for a driveway permit, the fire department would assign them a new mailing address.
so you can have, so the detached unit would have was that part of the bylaw that the detached unit has a separate mailing address?
It didn't address mailing identifications, so
Mhm.
the public safety officer usually assigns addresses based on what makes the units easiest to find.
Mhm. Um, was the line of sights for the driveway, did anybody take a look at line of sights and everything, how that all looks for the secondary driveway?
I drove past there and it seems fine. I didn't see any issues. The line of sight calculations were not submitted, but we don't typically require that.
Yeah, and this Coventry Wood, that's access to like a separate neighborhood. I think it's not typically it didn't seem like a main road. Not that
Okay.
line of sight doesn't matter, but it doesn't seem like it's highly trafficked as Sugar Road, at least.
No,
Yeah,
yeah,
Their driveway on Sugar Road is actually in a very busy, kind of dangerous spot right there. So
Right.
having egress onto Coventry is probably better.
Mhm.
Mhm.
And is that what the
Um,
plan is, or are they looking for guidance on where the driveway would be?
The plan proposes a driveway on Coventry Wood Road. They didn't request alternatives to that unless
Okay.
it's required under the Rivers Protection Act. It hasn't been proposed yet.
but given that, this makes the most sense.
I'd be fine with Coventry, yeah.
so the square footage is including the garage?
The square footage does not include garage. It's excluded from our calculations.
Yeah, it was
Living area is the 1,200 square feet, I think.
2 bedroom, 2 bathroom. I think 1199 square feet.
Because I guess well, I mean, could you just build a garage? I mean, it's not an accessory unit, but if it's bigger than 200 feet, then you just need the building inspector to look at it, I guess, right? So you're allowed to build a garage or a shed anyway, I guess you just consider it that.
In terms
Yeah.
of just a
I mean,
detached
just-
garage, you're saying?
Well, just in that it's not included in 1,200 square feet, but the thinking was that it's not livable space, right? So,
Right.
Yeah,
We went
bylaw
with the
is
state
livable space.
definition of gross floor area. And if you move forward with approving this unit, it might be wise to just include a condition that the garage cannot be converted to livable space. Just so
Yeah,
it's on record to make
Yeah,
people
that's probably a
aware
good
that
idea.
It can't be
or you
altered.
can't like build above it or something. Yeah.
One quick question now that we have this diagram up. Does this indicate that there's a basement? This looks like it's below grade. There's construction below grade.
There is a basement,
Yeah.
yes.
Okay, got it.
The basement, if it's under habitable area, it doesn't count towards the gross square footage. So if it's under 6 feet 9 inches or under, we don't count it towards the ADU square footage. If it's considered habitable space under the building code, then we do count it. That's how.
So above 6.9 is considered potentially livable space below grade.
Yes, that's,
Okay.
and we use the state building code to determine that.
Interesting.
And when it comes to, sorry, I'm just trying to refresh myself with the bylaw. When it comes to septic and water, Board of Health will manage that, making sure that the number of bedrooms that septic can handle it and everything. That's all.
I think
Yes.
there was plans to expand the septic, right?
Oh, okay.
Yes, and the Board of Health did submit a letter requesting additional information. So the applicant will be working with them to make sure their requirements are satisfied.
Okay. And then just procedurally, I saw in the application, they selected accessory dwelling unit, not the detached accessory dwelling unit.
Large, it should be large.
Yeah,
Yeah.
Large detached, right?
yeah. I mean, whatever, it's just,
That's fine.
No, that's a good point.
it was just confusing. But okay, I'm good.
Any other comments, either from the applicant or from the board?
What kind of wetland is it? Like,
It's
This is
There's
a stream, it
this
seems
perennial
like?
stream, I can pull it up on the map if you like, there's a perennial stream noted on our GIS system that the Conservation Commission identified.
I think it was a small strip on the bottom part of the property. It was pretty small there.
Do they, and actually, does the Conservation Commission even consider like flooding potential or?
They
blocking?
would if it's in a flood zone,
Floodplain?
but it is not located in a flood zone.
So it's something smaller than that.
So it runs along the rear of the property. With the stream not running, the stream's not located on the parcel, but an abutting parcel, and it's within 200 feet. But this just provides you with a general idea that everything would have to be surveyed, and a plan would have to be provided to the Conservation Commission.
Is this the 100-year storm calculation?
This is the 200-foot jurisdictional area from our perennial stream.
Got it. Yeah, it does look like it's right on the border, but yeah.
Okay, so pending approval from the Board of Health, the Neshoba Associated Boards of Health, and from the Concom, this is fine as shown, but we can't approve construction yet. Those two other permits have to occur. We don't approve construction, period, so.
Well, I mean, yeah, could we just approve conditional? I mean, on
You
those
can.
things, yeah,
I see no reason why not.
right. And then like just I think we want to make a point of what we said, that you can't make the garage or above the garage or basement. You can't add livable space, which are at 1,200.
And that would be up to the building inspector. I don't know that we need to put that in our conditions, but
Yeah.
Okay.
anyway. I will make a motion to approve the large detached accessory dwelling unit at 455 Sugar Road, pending approval from the Board of Health and Concom.
I'll second that.
Can I just suggest you incorporate a condition that the 50-foot setback be rectified on the plan?
Good point, yes.
Yeah, hang on. Amend the decision to also include that the 50-foot setback be amended on the plans.
That's from what, the side of the lot?
It's
Well-
from our, our
side.
front yard setback reads it should be from roadways, so it should be from both Sugar and Coventry.
Coventry, yeah.
Yeah, then the current plan is the 50, I think it's currently 52,
Yeah,
or
you
51.
have, yeah, you have it spaced correctly. I just want to make sure if you get into alternate locations with the Conservation Commission, when you locate the unit, that everyone's aware that that 50-foot setback does apply from Sugar Road.
And
Sure,
Coventry.
sure. Thank you. Okay,
Sure.
so nothing's needed from my side on the setbacks. I think they are all good, right?
The structures are good, but there's a setback noted on the plan in error off of Sugar Road.
Okay,
to show
gotcha.
you.
Thank you.
So the setback lines are marked on the plot plan you provided, and it shows a 20-foot setback off of Sugar Road, and that should be 50, so it should be set back quite a bit more.
Gotcha. Is this correction needs to be done from my civil engineer? Should I tell him to correct this?
Yes.
Yes, whoever completed this plan should correct the setback locations.
You must have
Okay.
interpreted that as the existing house being 20 feet setback from
Yeah.
the road. I mean, that,
Yes.
yeah,
Yeah.
yeah, in this case, it's going to be the new detached ADU, the setback for that.
Gotcha. Okay. Now I'm very clear. Thank you. Thank you for clarification. Yeah.
So
Did you-
Michael, do you want to restate your motion?
Okay, I will, let me do it all over again. I make a motion to approve the large detached accessory dwelling unit for 455 Sugar Road, pending approval from the Board of Health and the Conservation Commission, and also note to rectify the Sugar Road setback on the included plans.
Second.
Second,
Robert Romer,
aye.
Michael Lau,
Aye.
Austin Groner,
I
Michael Gore,
Hi.
Eric Nyland.
Aye.
The site plan is approved by a vote of 5-0.
Thank you all. A quick logistic question. So once I have my civil engineer corrected, the setback number from my ADU, should I submit the modified version through the portal, or should I email Pam?
You
What's the
can
right-
include it with your building permit application.
Okay, gotcha. All
And
right,
we'll make
will do.
sure it's incorporated there.
Thank you.
Okay, with that, shall we move on to the second agenda item, the approval, the A&R for Cottage City Distributors, 58 Main Street in the Industrial Zoning District. Pam, if you can put that up.
Yep.
Okay, do we have the applicant or somebody representing the applicant to briefly describe this?
Yes, can you hear me okay?
Yes, we can, David.
My name is Jacob Lemieux. I'm with Hancock Associates, 315 Elm Street in Marlborough. This is a subdivision of a large parcel in the industrial part of, or in the industrial zoning district. It's a large wooded parcel with steep slopes. We're dividing the parcel into 6 buildable lots and 1 non-buildable lot, which may be chopped up later and added to one parcel or another, but on its own is non-buildable. We've got four parcels with frontage on Main Street, 2 with Bolton Woods Way, and yeah, that's about it. I'd be happy to answer any questions about the specifics.
Yeah, I have a couple questions. So, I mean, seeing that this is an industrial lot, I would think like the typical build out of it would be a bigger either manufacturing or, you know, light manufacturing or some type of, you know, business. Like what's the thinking behind dividing it up to multiple parcels?
I'm thinking that my client wants to divide it up into smaller, lighter industrial use and contractor yard areas instead of keeping it as one parcel and building a much larger project. We think that because of the slope and the condition of the land out there, it's suited much better to having multiple leveled pad sites than trying to level out and build one project over the entire hill.
Mhm.
Which having been there makes sense.
Yeah. Pam, I mean, the way our lot coverage works is it can be divided up into multiple pads, right?
Can it? Yes.
Yeah.
It's a
So, I
one
mean,
and a half acre minimum with 200 feet of frontage.
yeah, well, what I'm saying is like you could build multiple pads if you kept it one lot, but I understand, you know, divide
You
it up,
could,
that's
yes.
fine. Yeah.
By special permit.
Yep. Is there
Any
any
other comments, questions?
oh yeah, is there any, do you know if there's any prospects, potential buyers? Or is it just kind of like future planning?
I know that there are a couple of prospective buyers looking at them, but I don't know who they are or where in the process that they are in that.
Now, Pam, dividing up non-residential land, is it basically the same bylaws where it just shape and frontage and all that? Yeah.
Yeah, A&Rs are not dependent on zoning districts, so A&Rs apply to any division of land that complies with your zoning.
I just want to say one maybe potential benefit of not splitting it up is you could share an access, right? You can have one driveway instead of five, right? Along a very busy road.
And we do plan on, well, as this goes and these sites are sold off, either individually or to a single buyer, they can buy them and recombine them and whatever they like. But hopefully, me and my client will keep doing the site design, and we're planning on, obviously, if we can have adjacent uses with shared driveways, we can do that by special permit, and that would be better for the town and our clients. So I think that would obviously be done during the site plan review, but would be something that we'd be looking at in the future.
Yes, and we would heartily encourage.
Absolutely.
Any other questions?
Nope.
Well, may I have a motion for approval of this A&R?
I will make a motion to approve the A&R for 58 Main Street.
A second, please.
Second,
Austin Groner,
I
Robert Romer,
Aye.
Michael Lau,
Aye.
Michael Gore,
Aye.
and Eric Nyland.
Aye.
The A&R is entitled to endorsement.
Thank you. I appreciate it. And I know it's difficult with the virtual meetings, but do we have a time frame that you think that the board is there a day that the board comes in to do signatures, or you guys just need a week? Or
I have the plans here in the office. I can notify you when someone stops by to sign them.
oh, does the board want to approve staff sign, or is the board going to sign each member?
We have one member authorized to sign
Okay.
it.
Okay, great. That speeds it up a little bit then. Thank you.
Okay, I'll be
appreciate
in
it.
the morning then.
Perfect. You all have a good night then. Thank you very much, and a Merry Christmas.
Thank
Take
you.
care.
You too.
Yep.
Okay, moving on to our third agenda item, a public hearing for special permit zoning bylaw 25017B, the common driveway surfacing 5 single-family house lots on Wattaquatic Hill. Assessor maps 004.C, parcel 00620066. The applicant's Wattaquatic Hill Road Realty Trust number 1.
I just want to note, we only have 4 eligible members to vote, and this is a special permit, so it would be a unanimous vote. We are expecting Jim Barr in about 5 minutes to join the meeting. I don't know if it's the applicant's choice to wait or if they'd like to proceed.
I guess it all depends if all 4 of you are gonna vote yes.
Can I suggest we just take the minutes and see if Jim can, oh, he's just logging in now, so. there we
Oh,
go.
excellent timing.
Hi, Jim.
Hi, Jim.
Just for the record, Jim Barr has entered the meeting. Okay, sorry for the interruption.
So moving ahead with this, Pam, do you want to summarize where we are with respect to actually a couple of issues?
Sure, at the last meeting, we were still reviewing the homeownership association documents. Were just submitted the day of the last meeting where we discussed this item. And there was one pending item identified by our peer review consultant addressing pre-treatment of the stormwater within a water intermittent wellhead protection area. So since that time, we received revised plans, HOA documents, and a letter from the peer review consultant just suggesting that the grass swale that goes through lot 9 be make sure that it's retained in its current condition as designed, and it is within the drainage easements. So we did incorporate that in our suggested conditions of approval just today. We went through the HOA documents. We had a couple of suggestions, and those were all incorporated into the draft conditions of approval. And all outstanding comments have been addressed or incorporated in as conditions.
So it sounds like we're on the verge of approval here. Comments from the board? I think everybody saw the document, reviewed it. There were a couple of very minor comments, nothing significant.
I have one question, if you don't mind.
Sure.
Pam, on the inclusionary zoning section, which is the last section, I noticed there was a question by one of the members, I believe, with regards to it says at the end of that, issuance of the 4th building permit, the fee must be paid. Is there a reason why it's the 4th, when the bylaw is basically sets up, anything over, I think it's over eight homes are built. I just question that to the point where if the end developer, combines 2 lots and puts 1 house up there, or and somebody wants a larger lot, so fewer homes are built. Is I guess is 4th could it not be the 7th or 8th even? Just a question.
The reason why and this is up for discussion with the board as well, but the reason why we don't save it to last is to ensure that no one walks away without paying the required inclusionary zoning fee. So if it's done sort of in the middle of the project, it allows for the project to obtain monetary inflow, and then it also doesn't wait to the end where there's a possibility that the funds aren't provided.
Okay, I kind of understand where you're coming from. still wonder, if something changed, could that be reimbursed potentially? Or
I don't know how that would be reimbursed in terms of a lot being omitted from the plan.
yeah, I mean, right, as we discussed, right? I mean, we're going through the common driveway permitting really for the purchase of sale of the property. The end developer may look at it and have somebody come in and say, I want to, buy 4 lots and put 1 house on there. It could totally change the whole idea of what gets built.
And if they're amending the plan that significantly, then they'd need to come back in.
Correct.
I see what you're saying. I would be amenable to making it higher. But I do think we need to have the fee paid before the final, like 1 or 2 building permits are provided.
Understood. Can we move it to 6?
It's really at the board's discretion, so I defer to them, but I just wanted to say that I wasn't opposed to it.
Yep. Okay, just asking.
Other comments and thoughts from the board?
This is 5 lots, right?
It's 9
So-
altogether. There's 2 A&R lots that abut the.
Oh, right.
Yeah.
Yeah, it's 9 total. The bylaw, I think, is based on 8 or more, correct?
Correct.
I'm allowed to talk, right?
Yeah.
Okay. I know we talked about like dividing it up per, I mean, if they are going to do fee in lieu of, like dividing it up per, per house or something like that, or maybe we could
Yeah.
do half at 4 and like the rest at 6 or 7 or something like that. I don't know if we can do that.
Well, prorated after 4.
Not
Spurs-
prorated, but we did talk at some point about changing the fee in lieu of process to where you pay a percentage at each building permit.
Yeah.
And from the
Yeah,
I don't think that's what the applicant is interested in here in this case.
No.
He's saying
Well-
that if it sunk below the 8 lots, then he
Hmm.
doesn't have to pay the fee. And so
Yeah.
if that were to happen, would he get reimbursed in that case?
Yeah, especially if it was early on. And I agree. I mean, more than likely the developer, when they come in and start, they will probably have a plan in place. And, so I would think it's something we probably know sooner rather than later, but
So you're building 5 now?
there's 5 on that common drive, but there's 9 total. So once you're over 8,
Right. But like,
Yeah.
so the common drive is going to be 5.
correct.
And then you don't know in the future when the other 4 are going to be built, is what you're saying.
Well, the plan is to sell it all as one lump piece of property. So,
See, it's
the
ki-
goal
it's-
is sell
it's
it all
kinda-
to one developer.
Yeah. So how does that work, Pam? Because I know like we were worried about this with like Century Mill, right? So like we give him the pass on the 5, then he sells it off to somebody else. Now that other person's,
And they say it's not my problem. Yeah.
yeah.
If this is a path, honestly, if this is a path you want to go down, I won't feel comfortable voting on this tonight. I would want to review it and think way more about that.
Yeah.
So,
Okay,
I
well, let's-
don't feel comfortable changing that at this point.
Because I mean, like, we've been in a position where it's like the day before Christmas and somebody's like crying that they can't move into their house and we have to keep waiving things. And then, like, so you're going to sell this off with like this, maybe you have to declare it or maybe you don't, I'm not sure. But like now this new developer is going to be like, yeah, I didn't realize this, I don't know. It's a tricky
Well,
situation.
yeah. I mean, at the end based on the agreement, it'd be more likely this money will be coming out of our pocket. After negotiating with the developer. So it will be, I mean, versus delaying it any further, I'll leave it at 4. If we can move it to 6 and it's not causing heartache, I'd be more than happy, but. I was just kind of questioning how it got to the 4th building permit, so that was my original
Yeah.
question.
Yeah, I mean, it is so we don't get to the end and then like, we have to hear sob stories.
Yep,
So,
okay.
well, we did change it to building permits also, so it's no longer COs. That was so we don't get the sob stories because of that. But
Yeah.
Pam, what are the percentages that we do split it up into percentages, right? So what is the percentage where the first fee kicks in the bylaw, right? Don't we, the issuance of the such and such building permit?
That's what I'm saying. I thought the bylaw was like we did it percentage wise. I thought we
Yeah, no,
spelled that
but
out.
of the overall development, I meant it was like at 33% of the whatever.
Let me take
I
a look.
can't. Yeah.
Yeah, I don't recall reading that, but I could be wrong.
Yeah, I don't know, but let me look. Make sure.
Well, without a lot more research, I suggest we stick with 4.
That's fine.
Payment in lieu of is pretty, so
One question from
that's for construction and how I'm sorry, Austin. That's for construction and how the units are to be constructed
Mm-hmm.
within the development. So that's how it's phased into larger developments when there's more than one unit and they're being constructed.
For one third of the projects, at 1/3 of the project is where it first kicks in.
Yeah,
If I'm reading that right.
Yeah, that's it. That's if you were building a unit, correct? And not
Yeah.
paying the
Yeah.
fee. Okay. So we can leave it as is.
Thank you.
and the only other question I wanted to run by the board in the draft of conditions was the construction hours. And if it should be permitted on Saturdays.
So I made that comment in there, and I think that we had changed from allowing construction on weekends to just having it be it had to be requested. Eric,
I don't really
Yeah,
want to
yes.
monitor construction on Saturdays either. I think either we should, and what could be allowed and what can't. I think either we should allow it or not.
So we disallowed it and said if there was a special circumstance, like, oh, my paving guy can only come in on the Saturday, like the board would listen to those special requests. But as a general rule, construction on Saturdays was not allowed.
Correct, Mike.
So I'll take that out then.
Yep.
I think we were doing it like on an as requested basis.
Yep.
Yeah.
Yep.
Sounds fair to the neighbors.
Interrupting all the people drinking their wine across the street.
That's right. They won't notice it.
I added a few things since the draft was distributed on Friday. They've all been in here for a little bit and they were forwarded to Mr. Stevenson.
Yep.
And if you remember correctly, I think it was another subdivision where the homeowners would contact. They were adding things onto. The police were getting called for Saturday work, and it was the homeowners that bought the house would let contractors come in and do, build a deck or what have you. So that turned into a little bit of a upheaval.
Yes, I do remember that.
Usually if we
I-
get those requests in this office, it's on like a Thursday or Friday, and do you mind if we work this weekend kind of thing? So I just rather say yes or no.
Say yes or no, meaning stipulated exactly in this document.
Yes.
Okay.
I was always fine with the like a one-off request of the board, like that was okay, but we just didn't want to make it
Yeah,
a blanket yes.
a general
construction on
exception.
Saturday. Yeah.
We required a condition that an escrow account be established, so when the stormwater maintenance and driveway is turned over to the lot owners of the single family homes, that there's money in place for maintenance right from the start, so we don't have to establish a home ownership association and get people identified to collect the funds right off the bat. There's some time to allow for that to occur.
Does that need to be added to that HOA document?
Yeah, I added it to the one I emailed you
Okay.
earlier. This it to the conditions, and it should be in the HOA as well, just so it's clear.
Okay.
And Pam, I made a comment about driveway turnouts. I don't. Is it enough just that they're on the plan and that they're built to that specification?
Yeah, they're on the plan and they have to be built, and then based on your comment, I also added a condition to be included in the homeownership association that they cannot be altered and they must remain clear during winter conditions.
I do know, talking to the engineer, they were, designed to certain specifications.
Yes, they're designed. We just want to ensure once homeowners are in the development that they don't remove or decrease the size of any of the necessary turnarounds, because they are provided for safety reasons. I can go through them or briefly, or I don't know how the board wants.
Yeah, let's just run through it for the record.
Okay. Proposed conditions of approval, all deeds for the 7 lots must contain reference to the HOA and the HOA documents and the operation and maintenance plans. The planning board requires that the applicant provide $3,000 upfront before the start of construction for inspectional peer review services. The limitation of construction activities is number 3. 4 includes a condition about the Board of Health determination and the submission of updated soil samples for arsenic and lead for their review and approval for any remediation plans. This was reviewed by the Board of Health and the Board of Health agent.
And did Chris talk to you?
He did. Yep.
Okay.
And he spoke to Chris Rogers, I believe he's the chair of the Board of Health. I ran it by the Board of Health agent, and they both agreed that the condition was sufficient to satisfy their concerns.
Good.
We just require notice that in the planning board that we be notified 7 days prior to the start of construction. And we conduct a pre-construction meeting with the applicant. We already reviewed condition 6, which pertains to the maintenance and preservation of the turnaround areas. Condition 7 relates to the fire suppression system and the use of residential sprinklers. Ultimately, the choice has to be approved by the fire chief. Easements for the homeownership association. There is a spillway for retention basin 38P, which overflows into abutting property. It is within the drainage easements, but the applicant needs to provide proof that they have legal rights to construct and operate that detention basin on the abutting parcel. So we requested that prior to the start of construction. We
Okay.
prohibited the use of, I'm sorry, is there a question?
No, that's fine. I just, it shouldn't be a problem.
We prohibited the use of sand when treating the roads during winter conditions, and they already have that in their homeownership association documents, excuse me. We request that the final documents, once all changes are incorporated, receive a final review by our town council. Prior to recording, we require annual inspection reports of the stormwater system be provided to the planning board on an annual basis. We just included a condition to ensure that there's a grass swale which runs along the frontage of Wattaquatic Road. So we incorporated a condition that if that were to overflow for any reason, that what runoff from the property cannot be spilled over onto the public way, and the applicant would have to propose some sort of resolution to resolve that if it does occur in the future. Condition number 13 relates to the grass swale on lot 9 and lot 2, and that's a result of the peer review consultant comments. If lots are sold separately, we just require that documentation of responsible parties for common areas be provided. And stormwater management system inspection and maintenance plan, we request be attached to the declaration, the homeownership document. So it references it as an exhibit, but we wanted to just ensure it's an actual attachment and gets recorded at the registry of deeds. So homeowners are aware of their responsibility. There's some additions we asked be incorporated into the O&M plan, including maintenance of the storm scepter that was left out. I believe it was just unintentional. Maintenance and checking of the overflow valves for the retention ponds and mowing of all grass swales. We required the applicant to establish an escrow account, $1,000 for each lot. That's part of the project. And that money be turned over to the homeownership association once responsibility is transferred to the lot owners. And then we include another condition 18 that the responsibility of the stormwater system cannot be transferred to the homeowners until as-built are provided and approved by the planning board. There are additional conditions related to erosion control. A phasing plan is required. And it incorporates limits of clearing and sequencing of construction. Condition 20, temp swales, direct water to temporary or permanent basins will be required as needed. There's a note that stormwater runoff is to be directed to proposed 4 basin basins. This requires retention basins to be constructed in the beginning phases of construction. Grading of basins must remain a minimum of 6 inches above final grade to allow for the removal of accumulated sediment until the site is largely stabilized. Temporary locations for stockpiles have to be noted on the plan. We just want copies of the NIPIDs and SWIP reports that are required by the state or EPA. Catch basins are required to have silt sacks once they are installed to ensure the stormwater system doesn't get silt accumulation. Dust control measures can be required as needed. This is just a general construction. No erosion can be no erosion can go off site, and we can require additional erosion controls if this does occur. There's berms in the fill. The retention pond construction requires fill on the back sides of the ponds with impermeable berms, so we required that they be peer reviewed by our inspector and a sieve analysis for the material utilized be provided to ensure it's not to ensure it's impermeable and matches the specs that are noted on the plan. This is construction standards for the gravel and the thickness of paving. That's straight from our regulations. This requires cleaning of all the stormwater system. Once the site is stabilized, the catch basins have to be cleaned and the storm system has to be vacuumed. So that requires those items be done. And we also required iron pins to be installed and included on the as-built for the limits of all bounds for drainage and common driveway easements, and that will just aid the homeowners in identifying what areas that can be altered and what can't, and what's under common maintenance requirements. This requires as-built for the common driveway. Once the project is complete, prior to the issuance of the final building permit for the single family home. And prior to the issuance of the final occupancy, we require a statement from the statement that the stormwater system was constructed as designed and is also operating as designed. If any portion of the system is not operating in compliance with the calculations and intent of the design, the measures are required to resolve the operational issues.
Can you just go back to that for a second?
Sure.
How do they determine without a great deal of precipitation whether it's operating as designed?
As designed. Well, it'll be in operation probably a good deal of time prior to final sign off on the project. So usually have a good idea of how it will operate long term by that point, because if typically the system the site will be pretty much stabilized prior to the as-built being provided.
Okay, I would be concerned that if it required an actual observation, that the occupancy permit could be held up, but it sounds like based on experience during the construction period, that's okay.
I think it should be. That's been
Okay,
my
that's-
experience with it.
That's fine. I mean, that,
To go back to Eric's point, like when we put contingencies on the occupancy permit, then someone shows up saying, "Oh my God, this guy walked away and I don't have a stamp for a PE stamp for the system." Does that have to be with the occupancy permit, or it can be with the building permit for the?
We can do building permit. It'll just make it earlier in the process, so there'll still be construction equipment likely on site. So my thought was to have it done later in the process, so we'd have a better idea of how the system is operating. But I understand what you're saying.
Yeah.
okay. Thank you. I just don't want an artificial, unreasonable impediment there. But it sounds like, as you say, during the construction period, you'll learn a lot.
That's basically we required plans of the as-built that's just specified, and this is just a basic one that's in the bylaw. The driveway may not be used to provide access to lots not shown on the approved plans. Numbering requirements, that's straight from our regulations, just to ensure
Right.
they meet the standards, and then the inclusionary housing condition. The board agreed to a $200,000 payment in lieu of to be deposited into our affordable housing trust, and as we discussed earlier, it is to be paid by the fourth building permit.
Great. Thank you very much. Sorry to put you through it.
That's
But I think it's
okay.
important.
I would just add, request we add one condition that two 24 by 36 copies of the plan be provided to the planning department, because we only have electronic copies right now.
That's already
We
on 33, isn't it?
That's for the as-built, so I didn't
Oh.
require it in
Oh,
the
yeah,
design
okay.
stage, and I need to have one for the decision and one for the clerk's office.
Yeah, we can get to that. When that's right.
Thank you.
Okay, at this point, I would expect that we would have to approve this document, and that without any other requirements, I believe closes the issue, does it not?
Well, we'll close the hearing if we're done
Yeah, right.
reviewing everything.
Okay, do I hear a motion to
So-
close this hearing?
I will make a motion to close the public hearing special permit, the common driveway on Wattaquatic Hill Road.
Second.
Robert Romer,
Aye.
Austin Groner,
I
Michael Lau,
Aye.
Michael Gore,
Aye.
and James Barr.
Aye.
The hearing is closed by a vote of 5-0.
And so Pam, sorry, what was the additional condition you wanted added?
I wrote it in there, just that, and I changed it from what I said, but I just like one paper
Okay,
copy
yep.
of the approved set of plans, 24 by 36 and one 11 by 17.
I will make a motion to approve the special permit for the common driveway servicing 5 single-family lots on Wattaquatic Hill Road, including the approval given with the conditions of approval document.
I'll second that.
Just for the record, it's conditions 1 through 37. On the draft of decision document dated 12/17/2025. Robert Romer,
Aye.
Austin Groner,
I
Michael Lau,
Aye.
Michael Gore,
Aye.
and James Barr.
Aye.
Okay, the special permit is approved by a vote of 5-0.
Thank you very much.
Thank you, John.
That was
John,
easy.
John, just so you understand the procedural issues, I have 14 days to sign the decision and get the board members, to draft the decision, get the board members' signatures and file it with the clerk. Once it's filed with the clerk, there's a 20-day appeal period.
Okay. Thank you. I'm sure I'll be in touch with you.
Okay.
Well, with that. So Pam, I appreciate all your help.
Thank you.
Thank you very much. Thank you, everybody.
Okay, next agenda item is continuation of our discussion of the Forest Mill study area. Pam, you want to summarize where we are? And we had a brief conversation yesterday about paths forward, or a path forward.
Sure, I just created notes on outcomes of the meeting. If you want to amend them, I'll put them in the OneDrive. Just input we received from various property owners at the meeting and things that we discussed, just to kind of highlight what we did. So I thought the next step would be to take that input, examine things under our current bylaw and what types of things would need to change under our current bylaw to allow the type of development that was discussed to happen. So things like Florida area ratios, shared services for parking and driveways, and smaller office space construction with multiple uses.
And then that would be in summary released to those who were invited to the original forum.
I'm sorry, what, I didn't hear what you were saying.
That summary of where we got and what the next steps are would be released to the people who were invited to the forum.
We can do that. I would present it to the board for your review first.
Yeah, absolutely. But I think we've engaged them. We want to continue to engage them and get our thoughts and their thoughts. And then start looking seriously at what the actual zoning changes would be. Now, one of the issues that came up, and Eric, it's near and dear to your heart, not necessarily positively, but a multi-use overlay district in that area.
Yeah, I definitely want to hear more. I mean, my inclination is no, but like when you listen to developers, they really feel like it's necessary, so don't want to rule anything out.
Yeah. Well, the Main Street study was not terribly enthusiastic about small business in that area, but I think we need to think about different approaches to small business. Certainly grouped business, smaller plots, area ratio mentality, etc.
I think yeah, I don't think they had the full picture of what we're talking about though. So
yeah.
Pam, as part of that document, did we capture just a few of I know we opened the floor up to the business owners for what are the existing concerns? What are some of the blockers today for promoting business in that area? We heard about signage, I think was surprisingly something that popped up a couple times. So do we have like a list of those things that we captured that we can include in the document as well? Just so the business owners know that we've listened, we've heard all their concerns.
Yeah, we didn't get a ton of feedback on things like that. Traffic was a big point of discussion, but they didn't say that other than Board of Health requirements, they didn't really specify anything from the zoning bylaw specifically that was prohibitive. But I think we got a good idea of expanding on the uses and the smaller scale of things that people wanted, buffers from the residential units that are there. No one wanted huge plazas or big box type stores is basically what we took out of that. I got from that. If you agree, I have that information on the summary sheet.
Okay, got it.
So that actually was an interesting thing that came out of it. I mean, I think we all here were never really thinking much about like the big solar array field becoming, a Costco, but like I could see how people would be concerned about that. So how do we deal with that? Well, yeah, how do we deal with that parcel? Because I mean the problem is it's like all the other stuff is kind of small, the stuff that's abutting 117 and Forbush. But it's like if we really wanted to have amenities or a Trader Joe's or something like that, I mean that brings that parcel into play. And so what do we do to,
And it's also not it's not a near-term thing, like so the lease is at least what 10, 15 years. So
yeah,
it's
certainly way out in the future.
Is it allowed to maximize the pad size, or would that be struck down by the AG?
Maximize or minimize?
To set a maximum limit on it, you mean?
Right.
Set a max pad size.
Yeah, no, we can do that with different things, like limiting the impermeable area and the FARs.
Yeah.
it would be difficult to say no commercial unit over 4,000 square feet or whatever number we come up
Well,
with.
I mean, like, yeah, even
Permitted.
4,000 square feet is, I think, we're thinking like a superstore, right? So.
Right.
We don't
Right,
need to
you
solve
can-
this tonight, but it's just something
No.
that I guess I really hadn't.
No,
thought
it's
of
an
before.
interesting question, and as we look forward, that would
Yeah.
be an opportunity for a big box store.
I mean, you would want something big enough that, say, a Trader Joe's could build on, but not so big that it's like a Walmart, I guess.
Right.
You should have a
Yeah.
Trader Joe's clause.
AG would love
we keep
that
talking
one.
about Trader Joe's, but
Bolton wants a Trader Joe's.
I think Mr. Wheeler didn't think that was feasible in this location. Given his
Well, I mean, I will
experience
say,
with
like,
that.
the
I don't think
EDC,
so.
the EDC, like, I don't know, 12 years ago, reached out to Trader Joe's and they didn't think the demographics there were enough people in the area, but I don't know. I mean, there's more people now and
Yeah,
there's
and
nothing like it. I mean,
Yeah.
really, the nearest, I mean, I always feel bad saying this in front of the owners of Bolton Orchards, but the nearest like grocery type store is pretty far away. So
yeah, and it's hard to predict the future. I mean, we're building a new 40B in our town. There's big plans in Lancaster for
right.
the property over there. We don't know what's going to happen in 10, 15 years. Maybe it's a perfect spot
Yeah.
for something like that, and we don't necessarily want to solve this problem prematurely if it
Yeah.
Now, particularly with what's going on in Lancaster, right down the street, that's huge. But again, and the other side of that coin is if you look at the Main Street study from 3 years ago, they're basically saying, nah, this will never happen. Well, they didn't anticipate what is going to happen.
The 40B was accounted for, but the Lancaster project certainly was not.
Yeah. Now, and the Lancaster project is huge, judging from what I've seen recently. Have you got any update on that, Pam?
No, not since the last meeting.
And I read in the paper that the state had come back to Lancaster and said, what do you want to put here? We'll approve it, as opposed to the other way around, which is the approach that's been, the state's been saying what they wanted.
Well,
Does
they
that
hired
sound-
a planning company to come up with conceptual drawings based on public input. So that's the process that they're going through.
Now, this is Lancaster did that?
Yes.
Okay, that's what.
I'm not sure who's funding the consultant, but they're working with the town and conducting public forums.
Okay. Okay, so you're going to put together this document. We'll talk about that next meeting, and then hopefully that goes off to the people who are involved in the first forum, and we start making more specific suggestions about how to do it. Okay, review of
Can I just
minutes.
ask, sorry, one more
Yes.
question. Did you get any feedback from the property owners outside of the meeting or no?
I did not. I don't know if anyone else has.
I haven't.
Feedback though, Pam, excellent job. It was very well attended. I was super happy with how many of the businesses showed up.
Yeah.
So great job getting the word out on that. Thank you.
Yeah, I mean, they definitely approached it with an air of skepticism a little bit, but rightfully so, considering the history of Bolton. So
Yeah. But no, I mean, it was a great
Yeah.
meeting. I mean, a good.
yeah, it was. Yeah, I agree.
Constructive feedback from them. And so
Yeah. No, I thought
Well,
it
I
was
think it was interesting that Frank Chiodo showed up and was, engaged.
Yeah. No, it's good.
Yeah, great job, Pam. And it was interesting to see, a good fraction of all the business owners in one small room in Bolton.
In regards to the signage thing, like I know we were going to talk about addressing that bylaw. I mean, could we do a signage by right unless the building inspector needs to kick it back to either us or select board? Like, do we?
It is by
We
right
have
now. It
Okay.
needs a
By right now.
so,
Oh, okay. Yeah, that's what we
Yeah.
did. I thought we did
Yep.
that.
Yeah, we did.
So yeah, I don't know. Like, I feel like
We
we've
were more
addressed.
complaining about, like, I mean, the classic pizza guy was like, oh, I would like the sign higher or over here or
Yeah.
what. I mean, it was more like
Yeah.
those sorts of things.
Well, as I understand it, he wants a large lighted sign.
Yeah, he
We've
wanted
had that
a
conversation.
illuminated. Seems like he wanted a few illuminated signs to be allowed. I don't
Yeah.
know that that's.
I mean, we allow down pointed down light, so
But-
that is allowed, but just not like neon signs, which I agree with that.
Externally illuminated, right?
Yeah, we allow externally illuminated, which I think that fits with the character of town to keep it that way.
Yep. Okay, to agree with everybody else, Pam, thanks very much.
Thanks.
It was a challenge, but it was a great presentation, and I think really it engendered a lot of feedback.
Yeah,
which is
no, it's really
just the
good.
fact that we got them in the same room was.
Yeah,
Yeah.
I was impressed with how many people actually came, so that was good.
It's great.
With the exception of a few residential homes and maybe one of the businesses, I think everyone was basically there.
Which business was this? The Essential Therapies?
No, they were there. Yeah.
They were
Okay.
there.
Yep.
Oh, sorry, got it.
She's the new owner, yeah, co-owner.
Deckett, and I don't think anyone from Keller Williams, the real estate office, was there.
Who runs Keller Williams now? In that
I'm not
office?
sure. That was one place I didn't visit because there wasn't anyone there, so.
Okay, review of minutes, October 8th. I took a look at them. I have no problem with them. Others?
Fine by me.
I will make a motion to approve the planning board minutes from Wednesday, October 8th, 2025.
Second.
Robert Romer,
Aye.
Michael Gore,
Aye.
Austin Groner,
I
Michael Lau,
Aye.
and James Barr.
Aye.
Minutes are approved by a vote of 5-0.
Okay, well, if there is nothing further to discuss in the way of other business, I'd like a motion to adjourn.
Motion to adjourn.
Second it.
Alrighty.
Right, everyone.
Night.
Happy holidays.
Happy holidays, everybody.
take care.
See you in the new year.
Bye.
Thank you.